Hello, everyone. My name is Susan Benish. I'm delighted to be moderating this panel for the ASIL virtual annual meeting on protecting human rights in the digital age. Can international law provide the necessary framework? We will do our best to debate and argue vigorously. And with such a magnificent collection of panelists, I can tell you one way or the other, it will be fascinating. I'm going to start by introducing them, and then our format will be questions and answers and conversation. And of course, we very much welcome questions from the audience. First of all, we have Cindy Cohn, who is the executive director of the Electronic Frontier Foundation. And among her great long list of honors, there is my favorite, which is the National Law Journal naming her one of the 100 most influential lawyers in America in 2013, saying, if Big Brother is watching, he better look out for Cindy Cohn. That is exactly right. And we are all very fortunate to have her looking over Big Brother's shoulder. We also have the magnificent Emma Alonso, who, as director of the Center for Democracy and Technology's Free Expression Project, promotes law and policy supporting internet users' freedom of expression, both in the United States and around the world, in many vigorous and effective ways, I'm here to tell you. Then we have David Kaye, who has been serving very constructively for all of us as the UN Special Rapporteur on the promotion and protection of the rights to freedom of opinion and expression since August 2014. Unfortunately, he will soon step down, but will continue to do other magnificent things along the same lines. David is also a clinical professor of law at UCal Irvine School of Law. Then we have finally Juan Carlos Lara, who manages the public policy and research team at Derechos Digitales, which is an NGO defending and promoting fundamental rights and the public interest related to the use of technology in Latin America. I am called Susan Benish, and I run the Dangerous Speech Project, and I'm faculty associate at the Berkman Klein Center for Internet and Society at Harvard. As I promised or threatened, I would like to turn this panel into a debate on the question in its title, which is, can international law provide the necessary framework for protecting human rights in the digital age? We can, of course, pose this question in a variety of contexts. One of the ones that has been on many minds now for the last at least couple of years is regarding content moderation. And David, you have proposed in number of talks and also in several of your reports as UN Special Rapporteur, that international human rights law can and indeed should provide a framework for content moderation by social media platforms. As you know, I'm pretty skeptical about that. So let me ask you to, first of all, to defend that position if you'd like to. Mm-hmm. And then I would invite all the other panelists to poke holes in it.
Right. Susan, thanks so much. And thanks for moderating this panel. It is so great to see such good friends, even if it's virtual here. Wish I could be in that field behind Cindy right now. That's pretty cool. So my view, and it's true, I've reported this to the Human Rights Council on several occasions, is that human rights law provides a framework, not only for states, but for the companies on all sorts of issues. So, I mean, on the one hand, I think it's probably an easier call for all of us to say that states, because they have obligations under international human rights law, they should be observing those obligations in the way that they regulate the companies, the platforms, telecommunications parts of the industry, et cetera. And at the same time, that the companies themselves should be using the framework of international human rights law in order to regulate, or as they say, moderate their space. And I think that means a few things. I mean, one, it means really adhering and implementing the UN's guiding principles on business and human rights, which say private actors need to observe the kind of impact that they have on human rights. It's not an obligation, but it is a responsibility of companies. But going further than that, I think that the corpus of human rights law actually provides an excellent framework and real good guidance for the companies to both articulate the rules that apply to speech and to enforce those rules, and also as a kind of realpolitik matter to articulate their standards, not as private standards, but as public standards to the governments that are making such demands on them. I mean, that's it in a nutshell, and we could get into the details for
Frankly,
sure.
to me, that's one of the most convincing arguments that having some form of external code to which the companies adhere in a systematic way would allow for greater transparency and greater accountability. That seems a pretty convincing argument. What worries me, David, as you know, is the details. Uh, if a company will abide by the terms of international human rights law in moderating content online, then presumably it must follow Articles 19 and 20 of the ICCPR at least.
Hmm.
And according to Article 19.3, states parties, in any case, may only restrict freedom of expression for 5 reasons, one of which is national security. Surely Facebook should not be regulating based on the national security of Brazil, China, the United States, Myanmar, or any country. And secondly, just to give another example of a way in which I think the law simply can't be used, at least as it stands, by companies for this purpose. The Human Rights Committee has clarified that states parties, in any case, may only regulate for one of those 5 reasons and not for any other. So are we to imagine that companies will no longer regulate, for example, to remove spam or to
Yeah.
increase engagement? Is that practical? Can it work?
Yeah, I mean, I think it can, and I definitely want to hear from the others on this, but I think it absolutely can. And also, I think that saying that human rights law should be the guiding set of principles for the companies is not to say that every element of human rights law can kind of be transposed into company rules. And I think that's actually a natural part of human rights law. One of the I think flexible parts of international human rights law is the attention that it pays to context. And so you're absolutely right. Something like national security may not be a grounds for Facebook or Twitter or YouTube to actually take down content, and that's something that we can debate. But when you look at the different kind of elements by which states are allowed to restrict expression, the famous in our world famous 3-part test, it actually provides really helpful guidance. It provides guidance around the what we call provided by law. So the standards should be articulated in a clear way so that people know what's on the right side and the wrong side of content that you can post or share. It also involves legitimate restrictions, as you mentioned, but some of those involve restrictions on the basis of the rights of others, which also can help us articulate an understanding that things like spam are problematic because they make it harder to express oneself, harder to get information on the platform. So I think there's a framework there. And I think you're right. As you get into the details, it can get complicated and may, in some respects, not even be all that useful. But it provides a framework. It provides a framework for transparency. It provides a framework for the companies to actually articulate in a globally accessible way what those standards should be.
Emma, you've been thank you, David, and it does sound as if maybe some lawyers would be handy uh, to interpret this law for what is really quite a novel purpose in many ways. Emma, you've also been very eloquent on this subject. What do you think? Can international human rights law serve as a framework for content moderation by companies?
So I think there's definitely a lot that we can draw from the international human rights law framework, but I also have a lot of questions about what exactly that looks like in implementation. I mean, I think it's kind of obvious. There would be no better set of international norms and standards and laws for companies to look to when trying to make these decisions. You know, this is the international human rights framework is the best thing we've got, and something that I know there's an enormous amount of global investment in. And so I think for that reason alone, it's absolutely worth serious consideration as to how it should apply to content moderation policies, particularly for companies that do have, you know, massive globe spanning users. But one thing I think I always like to bring into discussions about content moderation is the kind of the practicalities of what doing content moderation and content regulation at scale and at the scale of these online platforms actually means. Because I think it brings in a lot of different pragmatic questions that end up really feeding into everything that you and David were just talking about, of like, what does it really mean to translate these norms into the online context? One of the big benefits and one of the big, frankly, the requirements of international human rights law is that laws be specifically described so that people can actually understand what are the rules and how they apply to them. This is crucial to a law being legitimate. In the online content moderation discussions, there is always this kind of response from intermediaries, whether they're large or small, about concerns about gaming the system. If you are too precise about how you spell out what your rules are, it will actually give adversaries or malicious actors what they need to figure out how to get around your rules as stated and still continue to do things like harass or threaten or otherwise chill other people. And I think that is a real tension that's worth exploring. There's a potential response of, if your rules are that easy to circumvent, then you need new rules. But I think practically it also brings it back to the question for any company or any service that's looking to do this. If you start providing all of the Facebook implementation guidelines for their already very extensive content policies all at once, and then you start having lots of people gaming that system all at once, you're really actually coming into a resource constraint issue. How many rules do you revise, refine, and change, and kind of in what order and at what priority, to try to deal with the fact that you're in something of an arms race with bad actors who are going to try to exploit your system, in whatever way they can.
Although I must say, I've never been so convinced by that argument that if platforms reveal the true rules, that they will be making life tremendously much easier for bad actors. First of all, it troubles me from the point of view of what law is. After all laws are, and in fact, as David pointed out, Article 19 makes this explicit. Laws should be publicized and made clear to the people who are regulated under them. And if I've had platform staff say to me, if we make it very clear where we're drawing the line, then people will post content that is right up next to the line. They'll know exactly how to get very close to the line. And I say, well, that's the same thing with any body of law. You are showing people the line between what is lawful and what is unlawful, of course. And if you don't like them acting in a way that is nearly unlawful but is still lawful, then surely you should move the line, make the law different. The other thing is the argument that people can game the system once they know where the lines are, I think is undermined by the opportunity that people have to reverse engineer the rules by testing a lot. But
no, and if I could just quickly respond. So on the testing point, I mean, absolutely, that is the arms race that any system doing content moderation is already engaged in. And so it's, again, I do think this question of resources and how much do you want to sort of turbocharge the arms race that you're already fighting by giving away your playbook. But I think on this speech that is right up to the line question, this is an extremely difficult question. You know, I'm a First Amendment lawyer by training. I am all about right lines and keeping, like, you let the most atrocious stuff right unless it's clearly over the line. You know, that's when it's okay to regulate. In online content community, like online content spaces and online communities, you have a lot of really difficult interactions that you as a moderator are trying to oversee. And especially for issues like harassment and hate, people are very effective at figuring out how to stay scrupulously within the letter of the law and still do a harassment campaign against a people or a group of people. And that, I think, very understandably, is a kind of abuse that some platforms take very seriously, and that I would say most platforms should take very seriously. Uh, so I think there is also an element in how companies do content moderation of intentionally giving themselves some flexibility so that you have the opportunity to say, look, this maybe isn't a technical violation of this particular rule, but we can tell what's going on in this situation and we want to be able to address this particular abuse. Again, maybe the answer is you've got to continually refine your rules so that it covers every possible circumstance. But again, at scale and at the sheer number and diversity of communication and interaction that you're seeing, especially on very large platforms, that takes enormous amounts of time and resources.
Cindy, thank you very much, Emma, and I must take all of your points. Cindy, I've seen you nodding at different points. I maybe also shaking your head. What do you think on this, on international human rights law as a framework for content moderation? And then, if you want to draw us in other directions as well, please be welcome.
I mean, I agree with, I think, the consensus here that international human rights is probably the best framework we have for how to think about this. And I also think that one of the things we saw in the early days around questions around Google going to China and some of the things that were happening with Microsoft in China was that the fact that these companies each are little silos with their own set of rules actually allows a kind of really awful divide and conquer strategy from people who might want to limit human rights there. And so I think that one of the other reasons why using international human rights as a framework, and it's a framework, it's not, we don't live under the Napoleonic Code either in most places, right? We have a mix of hard law and interpretation in lots of systems around the world. Even I suspect the Napoleonic Code wasn't interpreted in the way that, as if it was just, there's a line, you go over it, as if it was like an engineering thing. It's not. But I do think it provides the best framework. And one of the things that we kind of saw at the time with this whole kind of should you put your servers in China question was that if we could articulate a standard that everybody had to meet and make that an external standard rather than internal standard, we actually helped all the companies. We helped all the players because they didn't have to justify their own situation. They weren't in a one-off situation. This is why we were trying to get for a while kind of a US rule around some of this kind of stuff, because then they can actually throw it to the rule rather than having to. Right now the lack of a shared agreement about what the kinds of standards are actually, it hurts all of us as the users, and those are my primary role. It actually kind of hurts the companies because they get played against each other a lot. So that's one thing. I mean, so I think human rights law is the right framework, and that we have to be honest with ourselves about all law, that people are going to game it and play it, and that international human rights law has made, I think, the right decision, which is it's better. People have to know the rules. We say this on the security side, security through obscurity doesn't work. And I would say the same thing about speech. Speech rules through obscurity doesn't work. It doesn't enable any more free speech, and it doesn't really give them any more power in the long run. The other thing we haven't talked about here, and I really understand the problems about scale. That is, I tend to be in general a kind of a fan of Ecclesiastes. There's nothing new under the sun. That most of the problems that we're dealing with in the digital world are not that much different than the ones in the non-digital world, except that there's a lot of mumbo jumbo and we pretend, and that the values of international human rights law are still the right values for today, and we shouldn't throw them out and create a new digital human rights law. We've got the right values. We just have to interpret them. But I do think scale provides the scale and the private nature of the scale provides something we have to think about. And one of the things that I kind of came to at the end of thinking about content moderation is that we need to fix the scale. Like, why is everybody's speech being hosted by one company that's 20 miles down the road from me? That didn't come down on stone tablets from the thing. I'm very biblical today. I'm not sure. It might be because we're in a pandemic, but we didn't, I think that, for us, a lot of our attention, we have the Santa Clara Principles, which is pulling out some due process ideas that we're trying to get companies to do. We work with CDT on that, and trying to get the companies, the giants that exist now, to exist better is absolutely not something we're stopping doing. But I actually think that creating competition in this space and creating more places for speech to be hosted is actually, I just don't think we should assume a world in which Facebook is the dominant place and Google's the only search engine and Amazon's the only place where you can order books. I mean, like that's broken in some really fundamental ways. And I think that while it won't solve all of our content moderation problems, smaller platforms can really moderate because they don't have to deal with scale at a level that's much better. And if you look at what Reddit has done to go from kind of being a cesspool to being a place that really isn't so much, it still has struggles, but it's not nearly the cesspool it was. That's in kind of ways because they really dove into making their community small, controlled, and kicking out people who were not behaving appropriately. And I think that, that's actually something we shouldn't throw off the table in these conversations. And, it brings in a whole other body of thinking about competition law and structurals and, what we call adversarial interoperability or competitive competition, competitive compatibility, so that we don't just have these gigantic arbiters of everybody else's speech anymore.
Also, very interestingly, Reddit from the beginning involved users in decision making about, and in not only decision making about the rules, but users, for the most part, made the rules. After all, every subreddit has its own rules that are entirely enforced by users, by members of that same subreddit who become moderators.
And I don't think that's a panacea. Reddit has a ways to go, but I think it points to a situation in which something that was bad actually got a little better. And if you look at how it got a little better, you might have some clues for what we might do. I think this kind of this tech world in which we assume a world in which Facebook is the gigantic player is one we ought to fight a little bit. The internet didn't start that way. It grew that way, and it grew that way because of some really policy and legal and other decisions and business decisions that we can undo.
Yeah, we're getting some really interesting questions from the audience, and so before we get off this topic, I'm going to ask the ones that are directly related to this. But first, I wanted to ask you, Juan Carlos, how you see this conversation about international human rights law with respect to content moderation.
Yes, I want to first thank you for being here, but also to follow on a few things that Cindy was mentioning, because thinking about the Bible when it feels like the end times, it's quite appropriate, but also because it's, for many people, a set of rules from ages ago, not just the Bible, but other religious texts from millennia in some cases.
What are you suggesting we propose to the companies?
We are still struggling to interpret those to everyday life. So if we have that with ages of knowledge, of course that would happen also with international human rights law. However, there's a couple of things related to what Cindy was mentioning about nothing being new under the sun, and at the same time, the fact that we keep coming up with new rules. I think those ideas can be made to interplay in a cohesive way if we understand that the core of the interest of the goods that we value are in international human rights law. The core of the issues we care about, the core of the rights in terms of the interest of individuals and collectives towards a certain value. And that involves also the core of the value of innovation and participation. So I also want to rescue that from Cindy's intervention, because I also believe that many of the problems that we have, even from scale, are born out of economic structures that have gone in a very extreme way towards the power of a few companies. But I want to add something that is basically from another point of view in that same scenario, which has to do with the fact that I come from a region of developing nations that do not necessarily have a lot of popular platforms by themselves. They are not necessarily bound by our laws, even though they've been taken to court constantly, for especially including issues of content moderation as well, because of search results, because of content that is posted on Facebook, content that is posted on Twitter, and also because in many cases they have been there has been content that has been taken down, uploaded from our nations, downloaded in our nations, but taken down under the DMCA rules, US rules. And that has happened recently in Nicaragua. It has happened a long time ago in Ecuador. It has happened throughout our history also to evade the application of local law. So the jurisdictional issue is one part where international human rights law becomes also useful, because it provides a standard for all of us, not just thinking about one company to another company, but also thinking about one country to another, which of course creates other problems regarding cultural mores and what is acceptable in one jurisdiction vis-a-vis another, which brings in another set of issues. However, if we can also leverage the power of international human rights law as a standard of the values that we share as humankind, and also about the core things that we care about, at the very least in broad terms, and especially in terms of how procedurally we go about moderating content online that is not acceptable for different reasons, then we have a framework that becomes more useful regardless of jurisdiction and regardless of the company that is trying to enforce those rules.
Yeah, I would point out that when we have these gigantic companies like Facebook claiming that they have one set of rules for the whole world, which is Facebook's claim after all, right? What it calls community standards for a community of more than 2 billion people includes a rule against nudity that is supposedly the same rule for Saudi Arabia and Sweden, which, if you think about it, is preposterous. And what I've understood from people at Facebook is that they get around this in a way by, or they have historically, by relying on the enormous disproportion in user flags in different countries. So users, as you might imagine, in Saudi Arabia are reporting nudity at a different rate and different types of content than in Sweden. But there's no question that with any single set of rules, internal or external to a company, there should be some better effort to apply them to different cultural and socioeconomic contexts around the world. And in my view, that ought to be more transparent.
Can I say on this, Susan, I think this is a really interesting place, because, when right now the companies have commercial standards, they're rooted in their terms of service. It's their discretion. They can do whatever they want, which they do have their own rights, certainly under U.S. law. But I would say even globally, they do have rights to provide space, and governments have obligations to enable that space for freedom of expression and other human rights values. But I think that one thing when we're looking at this kind of issue, nudity is a really good example. Right now, the companies do not have any consistency in their application of these norms and or of their rules. And the idea, your point about user flagging is the one that kind of triggered me in a way, because what that suggests is that the companies, rather than being responsive to their rules and rule breaking and enforcement of their rules, instead they are sensitive to public pressure, which is not rule of law. And I think that's a real danger, which is again why human rights standards can provide that kind of regularity, even if the outcomes are different in different jurisdictions, particularly around something like hate speech, which I know is a an area of expertise of yours, Susan, and I think for everybody. But even in an area like hate speech, it's okay for there to be variation across jurisdictions because context is so important to the law. But if it was all about public pressure, we'd end up in a place where there's a lot of totally legitimate debate and expression that is going to be filtered out and shut down by the platforms or by governments.
Yeah, I really want to underline that. I mean, the role that international human rights law to me plays is like the outer fence of what's okay. And, user pressure has been, especially, when the user is, say, the president of the United States, I think it's pretty easy to see how dangerous it can be to have the kind of organized mob decision making that often happens in some of these platforms. So to me, I think of international human rights law as kind of the corral under within which we can have a varying degree of responses, but that's the outer boundary as opposed to the thing that we look to for every single decision.
That's a very helpful.
But again, to take us back to the practicalities of doing content moderation, even on a smaller platform than a Facebook at scale platform. So I think, Cindy and David are absolutely right to point to the essentially heckler's veto style, potential manipulation for content moderation systems that rely on receiving user flags. But I just want to underscore that the other end of that spectrum is filtering of everyone's speech at all times against a set of standards that may themselves not be accurate, may be incredibly overbroad, may not be well understood the disproportionate impacts that they have on different groups and communities. So whenever the word consistency comes up, I really want to unpack it because I think there's consistency in kind of identifying problems, and that's a really big challenge that has kind of notice and flagging at one end, filtering at the other end, and a whole lot of questions in between. And then there's consistency of application of the rule to the content, however you identify it, that you end up evaluating, and that we need to be aware of the potential for abuse in both stages of that in content moderation. But I personally have also as many concerns with platform-wide filtering as I do with kind of the vulnerabilities of notice and flagging. And I know like everyone on this panel also has this concern.
No, I mean, look, there's Scylla and Charybdis right now. So I'm going to Greek mythology and I've left the Bible, but making our way.
Make your way to the Enlightenment.
To get a little more into the weeds, where I also love to hang out, Steve Crown asks us, besides ICCPR Article 19, which we discussed briefly in the beginning, what about ICCPR Article 20? I think, David, you mentioned it obliquely, but we haven't yet discussed Article 20, just as a reminder to maybe the audience. Article 19 sets out freedom of expression and the bases on which states parties may restrict it. Article 20 gives two types of content or speech in real life that states must prohibit under the ICCPR, and those are content. It's essentially advocacy of hatred that constitutes incitement to discrimination. Well, based on, I should have said, religion or ethnicity, that constitutes incitement to hostility, discrimination, or violence. And the second kind of content that states must prohibit, that is very often forgotten in mentions of Article 20, is propaganda for war. So what do you all think about Article 20 as a basis for regulation by social media companies?
Maybe I'll just say briefly, like, if we were drafting the covenant today, I'm guessing that those of us on this panel would not draft Article 20, right? It's for a number of different reasons, and there's actually been some really interesting work done on the negotiating history of it. But it exists, and I think one thing that we can say, maybe I'd say two things about it. One is it's not a generic hate speech provision, right? It's a provision that focuses on incitement, as you said, Susan, incitement to hostility, discrimination, or violence. So, it has to be, and this is where, the contextual issues come in. There has to be an evaluation of whether the content, it does constitute that kind of incitement. But the second thing that I would say about it is that there's been a lot of legal evaluation and development around Article 20 and its connection to Article 19, both by the Human Rights Committee and by other experts in the context of the Rabat Plan of Action. And I think there's a lot of useful material there that can be translated by the companies into their evaluation of content that they might think constitutes incitement of one sort or another. So I think there's a lot there. There are many tools that could be used by the companies in this context. And in fact, I think that there'd be a pretty decent alignment between Article 20 and what that would lead to and what a lot of users actually want when they're on the platforms. I don't think it would be hugely controversial to apply it. Would it be easy? No, we get into the weeds and we're all lawyers, so we love the weeds. But it would be, it is a framework that we could use that is much, much better from my perspective than just saying it's terms of service and we'll decide what we like and don't like on the platform.
The companies have in fact begun to ask how they ought to understand Article 20. So there's definitely room for some lawyers to answer them. Let me just offer another question from the audience. This is from Raquel Freitas de Carvalho. Please forgive me if I've mispronounced you. I would like to ask you if you think the technology and the boom provided by Corona will be able to submit itself to the disciplines of democracy and human rights, or will it be rolled out in a state of exception frenzy? This is something that actually Emma and I have recently published an op-ed, let's say not irrelevant to. So if you'd like to answer, Emma, you're very welcome. So is everybody else.
Sure. I mean, I will say briefly on the content moderation angle of all of this. A lot of us in the kind of digital rights and free expression community were very concerned at the start of the pandemic when we heard the announcements from Facebook and YouTube and Twitter about having to rely heavily on automation and how they were going to do content moderation during the pandemic for the very, very understandable reason that for the safety of their employees, they had to send their workers and their contract workers home from the massive warehouses where they do the kind of frontline content moderation. So having the human moderators kind of taken out of the equation or significantly reduced in the equation meant the companies were relying a lot more on automation. That we thought, and have a kind of coalition letter signed by over 75 different groups and individuals, kind of expressing this concern that this is, the definition of an emergency procedure. This is not something that should become the new status quo. And as the companies themselves kind of acknowledged at the time and have continued to sort of report and reflect on, primarily automated content moderation is not very good. There's a lot that they had to kind of, or at least a couple of the companies put notices out to their users that like, you can let us know you disagree with this automated decision. We can't staff an appeals team right now, so thanks for letting us know. It feeds into our kind of data analysis about how our tools are doing, but the option for remedy for people was kind of taken off the table because you need human staff involved in that. So I think there was the way that these major companies were responding to content moderation during the pandemic has been very instructive about the actual limits of these systems and what happens when you put an enormous stress on a system, like taking away most of the humans that we say need to be in the loop on content moderation decisions. And the outcome is pretty clear, not that good.
Yes, can I add something to that? Because it is completely right what Emma just mentioned with regards to the capabilities of the system. But at the same time, there's further stress provided, in fact, by the time of the pandemic, as we have seen in recent months, with the rules that have been passed through presidential decree in Bolivia, with the discussion in the Senate of Brazil right now, where they're discussing new rules against disinformation, which involve also tracking what people are discussing privately, so they can be tracked down to their source. And also because there's still pressure over digital systems and platforms that this broad and ineffective moderation that Emma was mentioning, that it becomes more strict. And especially to create this idea, or to promote this idea, that certain content can be detected by the platforms because they have done it so far, and that it should be more strict in order to prosecute people and also to identify misinformation and disinformation, which, at least in the Latin American context, is also rules just to prosecute people against which the political power may have animosity, risking their lives even in the pursuit of their political purposes. So I think those two things may happen, and of course, because a crisis is an opportunity to restrict the people in general terms, that may also translate to their behavior online. It's just not something that is restricted to the offline world.
There are an awful lot of very good questions, so I'm doing my best to get to all of them in the right order. Let me ask, on behalf of Amanda Grace Swenson, to Ms. Cohn's point regarding scale. Do you think the UNGP's, this is the UN Guiding Principles on Business and Human Rights, accounting for differential burdens on businesses of different sizes, could be helpful here?
Yeah, I think it's one way to think about it. And I think that we haven't, the United States is very, it tends to be really hesitant to scale things up based on size, but we're seeing more and more legislative proposals even here that do that. And I think the EU is actually a lot more comfortable with that kind of scale type of thing. But I think it might be a good way to go and begin to do some really serious thought about how one might do it. Counting, like, what are you counting, is actually its own question, right?
A very good question.
But I think it's worth doing, and I think that if we, competition law already deals with things like, how do you figure out whether somebody's got kind of monopoly power and things like that. So I think there's things to pull on, but I do think that's worth thinking about. And part of the reason I think about that is that, one of the things we're seeing, and frankly, the EU is a problem in this regard, is that they're so mad at the big tech giants that they're writing general rules that are going to entrench their power, right? Article 17 around copyright is one that we have, or I changed its number, but copyright filtering and copyright stuff is one of those situations in which we're seeing that the filtering type mandates that the EU is flirting with, let's just say, sometimes they say they not it, sometimes they don't, are going to entrench the current powers, because nobody can build the kind of filtering content ID system that YouTube has. And so what this means is everybody, YouTube's going to win. They're going to have this thing. And the same thing with Amazon's ability to handle some of the GDPR regulations. It meant that a whole lot of companies that were holding other people's data basically lost their businesses, because Amazon was the only one who could really do it at scale. Again, it's a more complicated story than that. I admit I'm generalizing, but I think that something that scales up based on the size could make sure that the rules that we make in the fit of our real big anger at Mark Zuckerberg don't actually make it harder to compete with him instead of easier.
Let me ask another quick question on scale. Do we think that, this is from Natalie Carpenter, do we think the pendulum is swinging away from scale, presumably large social media platforms, or at least primed to swing? Will the market begin to demand smaller platforms?
I want that to be the case. I would say that I don't see the evidence yet. I think there's a lot of talk, and that's great. That's how change starts. But I do think that I'm not seeing Facebook losing a lot of people in droves to, Mastodon. I often joke Mastodon is a federated social network, and that, I look forward to the day when Facebook is just another node on the Mastodon Fediverse. I would say that that is not the reality right now. And while there are lots of people trying to do this, Brewster Kahl's doing a bunch of things at the Internet Archive about creating more distributed systems and basically re-decentralizing the internet. Those are all still, they're still too small. They need to be bigger. So I'm not seeing it. And I'm seeing a lot of anger at the big tech companies, but I have to say it's somewhat incoherent because people, people on one side in the United States context, the conservatives are really, really pissed off at Facebook for a whole different set of reasons than the Democrats are. And just because everybody hates you doesn't mean they're going to agree on what we need to do with it. So, okay, everybody hates Facebook. Gotcha. But what to do with that anger is still very divided. And there was, you can look at the congressional hearings, which kind of feel like this weird, I don't know, my neck hurts from all the switching back and forth. That I think that some people, I think, especially in a DC context, thinks that because you've got bipartisan hatred that you're going to see change. And I have to say that I'm not at all confident about that.
I agree with that, but I would even say that that Washington is so much further behind some other places. So the debate in Europe, for example, even though it leads to places that are deeply problematic, the copyright directive is really a problematic directive out of the European Union. But the debate generally around content moderation, which has been, I think, a difficult conversation in Europe and highly politicized as well, it's moving to this new stage where they're considering the Digital Services Act. It is pretty sophisticated as a discussion right now, and it's in all likelihood going to lead to some very serious regulation that might actually cause some of the debate in Washington to be kind of overtaken by that event. Because, and it goes to your point about scale, Cindy, also, which is, because the companies are at such scale, they're going to want to make sure that their rules, generally speaking, and of course they can do geo-blocking and geolocation for all their different rules, but they're going to want some consistency in their rules, and they may just apply what, just like in the GDPR context, they may apply what Europe is asking. So that is going to have a major impact, and I think that the companies are going to need to pay a lot of attention to that, just as I think civil society already is looking at that to kind of hold Europe to account to ensure that that regulation doesn't, as was put before, reinforce the power of the companies, but also that so that regulation is actually itself consistent with human rights norms and encourages the companies to behave in a way that's consistent with those norms.
Got one more question on the weeds on the law itself from Stephanie Farrier, somebody on whose work many of us have relied. She wants to piggyback onto the conversation about the ICCPR by asking, what about Isert Article 4, which arguably would set a significantly higher bar for content regulation than Article 19 of the ICCPR. David, is that yours? Emma?
Sure, sure. We're all looking at each other. It's what's so hard about, it's hard to make eye contact and sort of, give it off to someone else. So it's a really good point. One of the interesting things about the ICERD, the Convention on the Elimination of All Forms of Racial Discrimination, is that when the committee of the CERD adopted a general recommendation on how to regulate, not online content in particular, but how to regulate this space, there was a pretty significant convergence with the Rabat Plan of Action. And even though the standards in the ICERD seem pretty tough and and as American lawyers, we might say inconsistent with First Amendment rights, the international discussion has interestingly moved to this place that is more similar to Article 20, where there's a very strong evaluation of context. And there's also a very strong evaluation, to my mind, of the continuing role of necessity and proportionality from Article 19 being imported into those other standards. So there is a development that suggests that, ICCPR and Isert are being read together, at least by the committees, the treaty monitoring bodies that are responsible for them.
Now we have two questions that will take us away from content moderation into other topics. One of them is from Kristen, who asks, can we switch gears and perhaps discuss facial recognition technology and how we might protect against abuses that the technology enables, relying, I guess, on international human rights law?
Well, EFF has spent a lot of energy, and we're very pleased to see local places. I think Boston just passed one, just banning facial recognition used by the cops. I think it's one of the technologies that is so dangerous to human rights that I think it's fair to talk about banning it and banning its use by law enforcement or governments against people. Then there's this other question, right? Because private use of facial recognition, there's some situations in which it can be useful, if you want to make sure that only people who are registered, get into your conference or whatever. But I still think it's really quite dangerous. It's one of the few technologies that we really need to pay very close attention to, not just because it's racist, which I think it is, but the argument to the fact that it's racist is, well, we just need to feed more black faces into it, and I think that's actually the wrong direction. So you have to, I absolutely care a lot that it's racist, but you have to kind of anticipate the next part of that conversation, which is that doesn't mean that all the world's faces need to get fed into it and get it trained, because that's going further down a bad road. And I just think that our rights to assembly, our rights to free speech, our rights to petition the government for grievances, search and seizure, all of the other rights really come into play when your face is tied to everything else you do in a way that is could be wrong, but also is kind of immutable.
A short addition to that, sorry.
Let me respond.
Very brief.
Have you relied on international human rights law arguments in your work at EFF on that, Cindy?
I don't think we have, honestly. I mean, we could, but it's been very hyper local. We a lot of facial recognition software is being used by local cops. Right. So if you want to stop local cops, you have local ordinances, and so it's more. I wouldn't say that we are opposed to applying international human rights law, but we're in it to win. And if you've got local law and local things will get the job done. To me, again, we don't need to go as high as international human rights law to find all the ways facial recognition is not okay.
Carlos?
Which is not to say that international human rights law doesn't play a role there, because even that work from the EFF has had its development also through the necessary and proportionate principles, which has also been an experience that organizations like mine and many others in the Latin American region have taken to go against facial recognition systems. Yeah. And also biometric surveillance systems in general, including some court cases here in Chile and in Brazil and in Mexico as well, both in terms of obtaining public information with regards to the acquisition of such systems, and also to try and combat them from a local perspective and under local law, considering these standards, but also understanding that these are measures that are collecting probably without, or most likely without, a legal authorization, personal data, and especially biometric, which is sensitive data, and therefore that principles enshrined in international human rights law, which is part of local law through the constitutions, is not being respected, and therefore that it's an illegal use of such technology. So all of those things are linked together when you do advocacy against a certain technology, even if it's done at a very local level.
Yeah. Oh, you're totally right, and I apologize. That's so American, right? Because you can't directly apply international human rights law in Boston, but you can in many, many places in the world. And certainly the necessary and proportionate, I'm so glad you brought that up because I had it written down. The necessary and proportionate work that we all did together, how many long years ago it was, to try to bring, an international human rights perspective to the police use of search, surveillance, and other kinds of tools. It kind of laid the foundation for lots of work around the world, and still continues to be a good a touch point. And again, we didn't set out to write a new human rights law. We took the necessary and proportionate principles, which are IDEA, which is old law, and said, here's how we apply it to the digital age.
And facial recognition, just to say really quickly, because I know we're almost up, is that, facial recognition is one of those things that crosses both the privacy law side of human rights law, but also the protection that Article 19 provides to anonymity. And so, it's one of those crossover areas that I think there's a lot of room for human rights law to play a really constructive role.
That's a great point. Now we have a vital question from Catherine Powell. With the rise of the touchless economy and contact tracing, how can we ensure privacy, also equality, what she calls color of COVID, which is a tremendous phrase, by the way, Catherine.
Well, we definitely have, worried a lot about COVID washing surveillance technologies, right? We're seeing a lot of it. And we have to fight it. I mean, there's luckily, a coalition of people who were around after September 11th, who watched everything get rolled over under the grounds of terrorism, came together pretty quickly. I think CDT was the convener of it, to make sure that we sound the bat signal early about that kind of problem. But it is a problem. I mean, fear is the biggest motivator for people to hurt other people's human rights. And it really, this fear is, it's a real fear. So what we have to do is really, come up with our structures for how we evaluate these proposals and apply them really clearly. And EFF has a 3-part test that we use to evaluate these kinds of things. And we have to be vigilant, because just because you're afraid doesn't mean the thing that the government is telling you to do is the right thing to do. That's where human rights are most always at risk.
That's unfortunately a very good place to end, and we are out of time. So I want to thank all the speakers for their really fantastic interventions. I wish we had more time, partly because you've said so many good things, and also because we have many more great questions. But I think, unfortunately, we have to stop. So thank you to everybody, including the audience, and hope to see you soon in real life and in person.
Yeah.
Take care.
Thanks. Thank you so much, Susan.
Susan.
Together.
Thanks, everybody.
Yeah,
Great to
thank
see you all.
Nice to see everybody.